Good afternoon, ladies and gentlemen. Thank you so much for joining us today for the MCIA's new series, Legally Speaking. The world at the moment is unfortunately reeling under a crisis like one never faced before. However, I cannot stress enough that it is institutions such as the MCIA and many others alike who must continue pushing forward their stated agendas without getting bogged down. Since our inception in 2016, the MCIA has focused on building an ecosystem for arbitration in India. A key part of playing the role of a catalyst for this ecosystem is enabling greater access to knowledge. Through the Legally Speaking series, we hope to bring you views and conversation from stalwarts at the bar, on the bench, and members of the legal community. For our first segment, we have two important individuals engaging in a dialogue. We have Justice Malhotra, Judge of the Supreme Court of India, and Sir Bernard Ricks, former Lord Justice of the English Court of Appeals. On the behalf of the MCI community and all those joining us live, I welcome you. I will introduce both our speakers first and then request Sir Bernard Ricks to commence the conversation, post which participants will be allowed to ask questions that they can submit on the Zoom app. Justice Indu Malhotra is a sitting judge of the Supreme Court of India. In 2007, she became the second woman to be designated as a senior advocate by the Supreme Court after 30 years. As an advocate, she specialized in the law of arbitration and appeared as counsel in various domestic and international commercial arbitrations, both in India and abroad. She was appointed as a member of the high-level committee constituted by the Ministry of Law and Justice, Government of India in 2017. She was appointed as a Supreme Court judge in April 2018, becoming the first woman judge to be directly elevated from the bar. Since her appointment, she has many significant judgments to her credit. Welcome, Justice Indu Malhotra, to our first series. Sir Bernard Ricks is a retired Lord Justice of Appeals to 20 years experience in the English Commercial Court and the English Court of Appeal. He is a member of the HKIAC panel of arbitrators, a member of the MOOGAS panel of international arbitrators and mediators, has been appointed to the Cayman Islands Court of Appeal and to the Singapore International Commercial Court. He is also an ADR Group accredited mediator. He has been appointed as a professor of international commercial law at Queen Mary University of London. So we are honored to have him as a member of the MCI Council as well. Thank you so much, sir, for joining us here today. I'll now hand over the reins of this conversation to Sir Bernard Ricks and request him to please start the first edition of Legally Speaking. Thank you so much.
Thank you very much. Can I begin, Justice Malhotra,
Yes.
by saying what a pleasure and honor it is for me to meet you, even in this virtual form, and to interview you.
Thank you. And it's a pleasure for me to speak with you too.
Thank you. Now, for those of our participants who may not be from India, and thus may not know of your background as much as Indians do, although there has been the introduction that has just been carried out, let me start at the beginning. I think you were, and when I say at the beginning, I mean the beginning, I think you were born in New Delhi and educated in New Delhi, and you were born into a legal family, I think.
That's right.
Because your father was a senior counsel.
That's right.
And you were only the second woman to become a senior counsel and the first woman to go to the Supreme Court.
That's right. But after me, many other women have got designated now. Several other women lawyers who now got designated as senior lawyers.
So trailblazer was exactly the expression that was in my mind. What does it feel like to be a trailblazer of this kind?
It feels good because the path was arduous. It was not easy. And when you make it, it feels good. And you feel very happy and fulfilled that the path has opened for other women also to get designated and to make their way up. So it's a great sense of fulfillment.
and this is particularly relevant because you've gone to the Supreme Court directly from the bar. Are you enjoying yourself in the Supreme Court?
I love it.
Yes.
I love judicial work. I think it's very, very fulfilling. I find it far more fulfilling than being a counsel. When you dispense justice, I think that kind of fulfillment you don't get by winning a case in the court as a counsel. So I think that is what I really feel happy. I enjoy it every minute. And when you are, laying down your working towards the progress of the jurisprudence of the country, I think that's something very great. I find that very fulfilling in my career.
May I say that I warm very much to the answer you've just given me, because I always have felt that my time on the bench, my 20 years there, was the most fulfilling work I have done as a lawyer. I loved the bar. I loved the competitiveness of the bar, and the idea that you were helping the courts to analyze and create law with your submissions. But the responsibility of doing it for yourself as a judge, I thought was a wonderful thing. So I warm very much to your answer. Now, you found time amongst all your work to bring to fruition a brand new 4th edition of the leading book on arbitration in India, whose origins, I think, go back to your father.
That's right.
It was his book in origin, yes?
That's right. He wrote the first 2 editions. The 3rd edition I brought out a little after he passed. And the 4th edition is actually a completely new version, because it has been I think the fastest growing area of jurisprudence in India. There have, in fact, ever since this book has been published, there are almost another 30 judgments which have been passed, which are very important. And I wanted to actually reflect the 2 major sets of amendments which have, been brought about. One was in 2015 and the others in 2019. So I thought it was very important that the book came out to clarify jurisprudentially what, is the position in law. And whatever free time I had, I spent it in doing up the book. And I'm very happy I was able to bring it out. But it was, believe me, a big challenge. It was very, very hard. Because the first few months after becoming a judge, given the enormous volume of work, it was very hard to work on the book. But I spent my summer vacations and whatever vacations I got and my Friday evenings trying to work on it so that I could bring it out as soon as possible.
Well, I'm very impressed. I was once offered the chance to take over a major textbook, a textbook I greatly admired, but I didn't dare.
It is very difficult. It is very difficult. It's very imposing on one's time.
Yes.
I mean, there was actually no time for leisure.
Now, apart from paternal influence, how did you first get involved and fascinated by arbitration work?
It was actually in my practice. As it grew, I did get engaged in a lot of arbitration work, and then I really developed a passion for it. And I found it very, I got appointed as a sole arbitrator in a lot of matters by institutions while I was a senior lawyer. And I was appearing in some international arbitrations. And after I brought out the 3rd edition, the government had nominated me as a member of the high-level committee. And then I went into the act in a lot of minute detail and made recommendations along with my colleagues on the panel for the 2019 amendments. So we had actually made the recommendations, most of which have been brought into the legislation of 2019. So the interest, I think, just grew, and the book really became a passion for me that I wanted to, make it the Red Fern Hunter of India.
Marvelous. Now, the 1996 Arbitration Act of India, which is the subject matter of your new edition, in the last few years has been under almost constant revision, it seems to me, as an onlooker from afar. Now, what do you think is driving this constant revision?
What has driven it is the government's commitment to bring about a progressive legislation which is in sync with contemporary international practices. And they also wanted to promote the ease of doing business in India. That was government's. So they wanted to bring the arbitration legislation at par with contemporary practices. So there was the Law Commission, which was constituted in 2014, which made these substantive recommendations. And I think the 2015 amendments were the major milestone in India's arbitration legislation. And the World Bank rating of India, it considerably and significantly stepped up. It's significantly, I think we are at number 63 today. So we've climbed up because of the legislation on one side and the judicial decisions, because I think the courts have very clearly in the past over 10 to 15 years, you will rarely find that a foreign award has come to this country which has not got enforced. The only problem which I will admit is that it takes time for these matters to get concluded in the courts, given the huge amount of litigation that we have to deal with. So when the enforcement comes to the courts, it does take some time. But believe me, you will hardly find one case, of the Supreme Court, which was passed 3-4 days back. That was it was under the old Act, the Foreign Awards Act of 1961, where an award has been set aside, but you will not find any other. India has done extremely well. Both the judiciary and the legislature have been making this effort of, being an arbitration-friendly jurisdiction.
Well, it seems to me very important. India is such an important economy in the modern world that it's coming aboard the world of international arbitration, it seems to me, is a most important thing. And I'm not at all surprised to hear that the World Bank has been impressed. Now, one of the most recent revisions is the creation of an Arbitration Council of India, one of whose tasks, I understand, but you'll correct me if I'm wrong, will be to regulate arbitrators in Indian arbitration. And I note that such arbitrators under the new, possibly still to be notified, I'm not sure, 8th schedule to the Act, will have to have prescribed qualifications, such as 10 years practice, which one understands, but also will have to be conversant with the Constitution of India and labour law, as well as, of course, with commercial law and contract law and tort law. I just wonder how many international arbitrators like myself will manage to familiarise themselves with the Constitution of India, fascinating as that is.
Okay, I'll explain the backdrop to you. First, let me say at the outset that the 8th schedule does not apply to foreign arbitration practitioners who come to India. I mean, please don't have that misconception, because I know the 2019 amendments came in for a lot of criticism by arbitration practitioners in other jurisdictions, but it was based on a misconception. These qualifications which have been prescribed by the 8th schedule are for Indian practitioners, that they should have either of these qualifications, basically a qualification plus 10 years experience, so that the arbitration which is conducted, domestic arbitrations, is of definitely a good level. So that was basically, it's only for domestic practitioners. It is in part 1 of the Act, and part 1 deals only with domestic arbitrations. This is the first point. I'll give you a background of this provision which has been incorporated. This provision came pursuant to the high-level committee's recommendation. It is not a regulatory body. It does not have any power to blacklist an arbitral institution or do any such thing. The reason why this council has been conceived is it's a statutory body to promote arbitration. It is to enable arbitration practitioners, Indian arbitration practitioners, to obtain accreditation from institutions. It's only to improve that, to make recommendations with respect to legislative amendments. Another purpose for which it has been set up is that a depository has been created. And the reason for this is that till now, most 90% of the arbitrations in India were ad hoc arbitrations. So when we were on the high level committee, a recommendation was made by a lot of senior Supreme Court and High Court judges and arbitration practitioners, saying that when the award comes to the court, how do we get an authentic copy? Who maintains the record? Because both parties go their own way, and arbitrators said that we can't maintain your records, please clear our office. So it became a big challenge, and that is the background of creating an electronic depository. So these were the functions which were ascribed to it, and the major function was to grade arbitral institutions, and that was for a specific purpose. The purpose was that the legislature wanted the default power of appointment to be shifted from the court to arbitral institutions. They wanted to move from ad hoc to institutional. So now, which are the institutions which would make the appointments? So the legislature found that this body will do the grading, and on the basis of graded institutions, the courts will delegate the power to make the appointment, so that you wrest control from the courts, minimal judicial intervention, and you move it to the institutions from the beginning. So that is actually the role of the Arbitration Council. It does not have any regulatory or penal role where it can blacklist an institution, none of that. It is only to upgrade the entire arbitration system in the country. That is basically the focus. And there are no regulatory powers. It's a promotional institution.
Thank you very much. That was very clear. It was put to rest some misconceptions which were in my question. All right. What about the timelines for arbitration? That's also something which has been revised in recent years. So I believe that just a few years ago, a new amendment to the Act prescribed a 1 year, broadly speaking, a 1 year timeline for all arbitrations in India, with the possibility of an agreed 6-month extension. But after that 6-month extension, if you needed more time, you had to go to the court and get permission from the court. And I understand that the latest revision has now limited that timeline to domestic arbitrations, whereas for international commercial arbitration, the 1 year timeline plus 6-month extension, and I think the timeline goes from completion of pleadings, is a matter of endeavor only. For international arbitration, the timeline is a matter of endeavor only. You are under the expectation of acting as expeditiously as possible. There is an exhortation to endeavor to meet the 1 year timeline, but that's as far as it goes. Now, what's the thinking here, both in the original form of the statute a few years ago and now in the amendment to exclude international commercial arbitration from the most forceful part of the prescription?
I'll give you the background to it. As I just said a moment ago, that the majority of arbitrations in India were ad hoc. So they were completely unregulated and there were no timelines. There was a delay in conducting the proceedings and in the delivery of the award. So the legislature, when we were on the high level committee, we made a recommendation that put a statutory time limit, and that had its expression in section 29 capital A. This was a new provision which was inserted in the 2015 amendments, which said that 12 months is the period from the date the tribunal enters upon reference. Now, after that, this committee was constituted, which I was just talking about, high-level committee, and there were representations made by leading practitioners, that is arbitrators, as also by institutions, like most of the international institutions like CIAC and others. Their representatives had come before us, and they said, please treat international commercial arbitrations at a different level, because we monitor and we conduct the proceedings. So you don't need to give us a statutory time limit. We see if it is necessary, so please don't impose these time limits on us. Insofar as domestic is concerned, the arbitrators felt that 12 months, more than half the period would go away in the completion of pleadings. So they would not be left with adequate time to conclude the proceedings, the hearings, the evidence, and pass the award. So their suggestion was that why don't you give an initial 6 months period for completion of pleadings, and let the 12-month period start ticking after that. So it was 6 months for pleadings initially. After that, the tribunal takes on, and for 12 months, they complete the pleadings. That was the backdrop in which the amendments were brought about. Insofar as international is concerned, it was decided to make it, they said, put in an endeavor to try and complete it within this period. So it was mandatory for domestic, it was an endeavor for international. That was the background of these amendments.
Thank you. Thank you very much. Let's talk about the enforcement of foreign awards.
Yes.
I want to talk about that. Now, enforcement, of course, is governed by the New York Convention, to which India has long been a signatory. In the past, the odd criticism has been made that the Supreme Court of India was too ready to refuse enforcement on the ground of public policy, which of course is one of the stated defences to enforcement under Article 5 of the New York Convention. Now, what would you say about the current culture of enforcement of foreign awards in India is?
Okay, I'll first give you the legislative amendment which was brought in by the 2015 amendment on public policy. The Act, the 1996 Act, Part 2, which pertains to the enforcement of New York Convention awards, is verbatim the grounds which are contained in Article 5. So it is identical. The only change which we have made is with respect to the public policy exception. In that, now the only three grounds under public policy are, one is that if an award is procured through corruption or fraud. The second is that it is contrary to the fundamental policy of law, not merely a violation of some statute, but fundamental policy of law. And the third is that it is in conflict with the most basic notions of morality or justice. So the public policy exception has been made very precise. It's a narrow construction, and there's a second explanation which has been inserted, which clearly says that no review of the merits of the award. So a narrow construction is given, and I think you will not find a single judgment in the last decade, at least, if not more, where enforcement of an award has been refused. They have all been implemented except one judgment which was passed 3 days ago, and that was with respect to, it was under the Foreign Awards Act of 1961, and that was with respect to a case where the arbitrator of the claimants had gone and acted as counsel before the Board of Appeal, And this interpretation was given on the basis of the provisions of the contract itself. They said if the government comes out with a prohibition of exports, then further exports cannot happen. So it was on an interpretation of that enforcement was refused. But otherwise, you will not find it. And I think almost every judgment of the Supreme Court, the latest one being Vijay Karya, where the Supreme Court has been granting enforcement without exception. The Supreme Court, the High Courts, Bombay High Court, Delhi High Court, I think without exception have been granting enforcement of foreign awards. So that is not really, I don't think one can have a complaint now insofar as the legislation is concerned or judicial interpretation. The only problem is the time it takes for matters to get concluded. But we have tried to fast track it. In fact, these matters in the Supreme Court have got concluded also within a few months. It was a special petition which came in 2019, and March 2020 the judgment was delivered in Vijay Karya. So things have got expedited considerably in the courts also.
Well, I think there must hardly be another nation in the world which has made it so plain in its statute that public policy is really talking about international public policy, matters of concern in every country of the world, rather than solely Indian public policy. And I don't think there can be many countries in the world which have made that as plain as the 2015 amendment has. Thank you very much for that explanation.
There's one other thing which I'll tell you. Even with respect to a domestic arbitration, the same narrow interpretation is given in our statute for public policy, even for a domestic award. So we brought it at par, making it an extremely narrow exception. It has to be the fundamental policy of Indian law, morality and justice, most basic notions of morality or justice.
Thank
so
you very
that is all.
Well, Professor Bourne must be pleased with this. Now, what about the supervision of foreign-seated awards? Is there any danger nowadays that the Indian courts would seek to interfere with or set aside such foreign-seated awards?
Post the Barco judgment, which came in 2012, there is no such interference. And the 2015 amendments have made one important amendment, which is in section 2.2, making a provision for the grant of interim relief for foreign-seated awards, and appellate provision for that. And third is court assistance in taking evidence for a foreign-seated arbitration, but no interference with it at all. Because I think the seat courts, there is a lot of jurisprudence in India with respect to the seat court and hands off if it's a foreign seat. So that is the approach.
Well, now, thank you very much. You've answered all my questions most helpfully and clearly. I wonder if you have any questions for me, Justice Malhotra, because I was told you might.
I was wondering how you all were dealing with the COVID issue and, being a force majeure situation with enforcement of contracts. How were you dealing with it?
Now, I don't think anything is. You don't mean procedurally. You mean on substantive law. I assume the courts are more or less shut down for the moment. But I can see that COVID-19 is going to create over the next few years a new rash or group of frustration cases. So you may recall that the First World War created a lot of frustration cases because of the requisition of ships and things like that. The cancellation of the regatta that was planned for, I can't remember whether it was King Edward or the new King George V. Just before the First World War, there was a cancellation of the Great Regatta. That caused a group of frustration cases. The closure of the Suez Canal caused some frustration cases. More recently, not so very many. I had to deal, when I was in the Court of Appeal, with a case called Edwinton, which was concerned with the possible frustration of a very short charter party, salvage charter party, when a local port authority interfered and detained the vessel. We held that charter party was not frustrated. But I can quite see that COVID-19 is going to cause a great deal of litigation, well, undoubtedly a great deal of litigation, but it's going to cause a whole lot of new cases on frustration. And it will be very interesting to see how those cases develop. Now, one of the difficult things about frustration is how long does some impediment last? And of course, you can't deal with it as a matter of hindsight. You're always forward-looking. What would the reasonable person say about the situation as it is at this moment, given what has happened in the past and given what the best view of the future will be? And these judgments are very difficult to make, and merchants are going to have to make them. And so much will depend upon how long the present restrictions and lockdowns continue, and what our best estimate of that is. And these things will be worked out in hindsight, but the test is always forward-looking. Now, that's the doctrine of frustration, which of course is a common law test. But many contracts contain prohibition clauses or force majeure clauses. And those contracts will all have to be adjudicated upon their own particular wording. So we know that oil exploration and production contracts frequently have force majeure clauses within them. Sale of goods contracts for food commodities and soft commodities, and also minerals and metals, will contain force majeure and prohibition clauses within them, and they will depend very much upon the individual wording of those contracts and the particular provisions of each country's statutes. To some extent, lockdowns have operated, forgive me, so my phone going. To some extent, countries have begun lockdowns by guidance rather than by statute, but have quite quickly gone from guidance to statute. And these statutes have been enacted very quickly in a slightly rough and ready way. We don't really know much about them other than what we're told, unless we're lawyers who have to study it. And even in public discourse, in Britain, for instance, there has been some confusion of language when politicians speak to us on the television in their daily broadcasts as to what is law and as to what is sometimes called guidance or advice. And on the whole, the politicians, although they have had to go to law to tell us what to do, have preferred still to talk about it on the television as though it was guidance or advice, because they have slightly flinched from telling us just to what extent our liberties in these extraordinary circumstances have been curtailed by law and not just, as it were, by government request, advice or guideline. So all these things are going to have to be worked out in due course. What is law? What is guidance? And in certain areas of the law, such as insurance law, for instance, it may be that guidance as well as law will have its effect on bringing cover for insureds under insurance policies, business interruption policies, and so forth. Now, there's going to be, unfortunately, a lot of litigation, a lot of arbitration on these questions. It will be interesting to see.
What do you think will be the impact on investment claims in developing countries?
Gosh. Well, all I can say is we are all suffering. We are all suffering from the same problems. And I think that will teach us to have a better understanding of the difficulties which countries face in what is a worldwide problem in which the safety of our populations and indeed the structure of our economies have become the emergency problem of our state legislatures. So I would like to think that we will reach rational and fair and reasonable conclusions about this. It does seem to me to be a case where we have had to act in an emergency situation in matters of health, which is as strong an area for public policy as one could think of. What one must hope, however, is that we get on top of our difficulties sooner rather than later. It remains uncertain. Will we obtain therapies which will enable us to relax some of the more stringent lockdown provisions? Will we ultimately get a vaccine which will be a solution? Some people say that we will have no ultimate solution without a vaccine. And people of my generation are saying, we're stuck at home until we have a vaccine. And I've heard some people of my generation say, we won't move and we won't start to travel again without a vaccine. So I hope a vaccine will come for all our sakes. But a lot will depend upon how quickly we can get things moving again, and a lot will depend upon how quickly states will relax the enormous powers that they have given to them in this emergency situation. I mean, one must hope that democratic states, who are very reluctant to impose these restrictions upon our liberties, will give up their new powers as soon as they safely can. States which are less democratic than the most democratic of states may be tempted to keep some of their newly enacted powers, even as the health emergency recedes. And one must hope that as little of that happens as possible. If it does happen, then one can see that there will, in due course, be greater conflict in the investment state arbitration area between investors who say, well, we understand the emergency taking of these powers to deal with the emergency, but why are they still in force, mucking up my investment? So there may be disputes of that kind coming up down the line, potentially, but we will have to see.
I think apart from loosening the control and the power, the impact it's going to have on the economy is what is, I think, going to be determinative. of whether these investments, how far they could have been taken and how far they'll have to, cut back. Because the economy has been affected drastically. So
Yes.
for the economy to also hop back to normalcy will take a long time.
Yes.
So that is going to have its impact on the enforcement of these contracts.
Well, I do see that fascinating questions for lawyers are going to arise out of this. I think all lawyers and courts are going to be very busy with the problems which COVID-19 has created. And as lawyers, one perhaps can look forward to deciding some of these interesting questions. I have, however, the greatest sympathy for leaders, whether they are political leaders in government or business leaders or the heads of charities or of religious institutions, anyone in a position of leadership in this situation, I really do have the greatest respect for, because they have all had to take very difficult decisions very, very, very quickly. I have just glanced at my watch. I see that we've been going 40 minutes.
Okay.
And perhaps I should ask whether now is the time to ask whether we are ourselves going to be asked some questions by our audience or what. So what shall we do? What shall we do?
We can ask Neeti or Madhukeshwar as to whether there are questions from the panelists.
Neeti, are you there? What position are we in? Hello, Neeti. I've just pressed on Q&A, and I see that there are some questions. Shall I read them off the screen? How much time have we got?
Sir Bernard and ma'am, we have about 5 minutes. If we could take the 2 questions which have come in now, which is on the confidentiality of arbitral awards. What's the position in India and what's the position in England on the confidentiality of awards? And I think the second question, one of the attendees have asked is, if a tribunal rejects a virtual hearing during the COVID-19 situation, then do you think that that would amount to a breach of an opportunity to present your case? So if you would like to comment on these 2 questions, please.
All right, just repeat them again. One is our view on confidentiality of awards.
That's right, Sir Bernard.
And the second question is, just repeat it.
It's if a tribunal rejects a virtual hearing at this time of COVID-19 situation, would that amount to a breach of a principle of natural justice and an award can be set aside on that?
Well, would you like to go first, Justice Malhotra, on either of those questions?
I'll answer the confidentiality clause. In India, we did not have a confidentiality clause till the 2019 amendments. It has now been specifically incorporated that all proceedings, arbitration proceedings, there will be a confidentiality clause and that can be enforced. So we have made this amendment in 2019, insofar as the Indian Act is concerned.
Yes. Well, in England, we don't have a confidentiality provision in our statute. In 1996, we decided to leave that out. Jurisprudence has confirmed that arbitration is confidential, and that extends to an award. But there is, I'm glad to say, some jurisprudence which says that we ought to distinguish between the confidentiality of hearings and the process of arbitration and the confidentiality of awards, which is a different matter. I myself am less than 100% keen on confidentiality of awards. I think that we ought to try to investigate the possibility, with the help of important arbitration institutions around the world, to see if we cannot, hopefully, of course, with the consent of parties, move to a situation where we can publish in anonymized form, perhaps, perhaps 6 months or a year after the issue of the award, more awards. There are, of course, publication of certain awards in investment treaty arbitration. They're all published, doesn't do any harm. Because I'm slightly fearful that despite the great success of arbitration, in the long run, too much confidentiality will cause two vices. One is what goes on in the dark may not prosper in the dark. And the other thing is that with the success of arbitration in international commercial work, we are depriving our jurisprudence, our public jurisprudence, of cutting-edge development of our commercial law, which is very important. Now, shall I go first on the second question? Would a denial of a virtual hearing lead to problems? Well, now, if you deny a virtual hearing, then you have to have an in-person hearing, and you can't have an in-person hearing, and so you're not going to get an award. I think the real problem is if you allow a virtual hearing and say we are not going to adjourn until a time when we can have an in-person hearing, and you force the parties to have a virtual hearing, might it be said by one of the parties, oh, but that's unfair because it is only by person-to-person cross-examination that you can really get to the bottom of this case, and it has been too difficult to manipulate the documents vis-à-vis the tribunal, vis-à-vis the witnesses, and so forth, and that this has led to an unfair hearing, and that the award following a virtual hearing is not sustainable. So I think that's the way that the question would arise. And we're going to have to see how that works. One hears that virtual hearings can be a success. I don't know whether people are talking about shorter, smaller virtual hearings. One doesn't know whether one's talking about virtual hearings in which the tribunal has had the ability to have hard copy trial bundles to assist them with the hearings, because there is a difficulty. You need one screen for the faces, you need one screen for the transcript, you need one screen for the documents. Are we all in a position to have 3 screens? Or can we, as we are working now together, 3 faces and questions on the screen, can we all put it on one screen? Well, I'm not sure. Justice Malhotra, what do you think about the second?
I would agree with what you say on the second issue. It's not an easy question. I think probably the tribunals would adjourn the hearings for a little while, because one doesn't know how long this is going to last, how long this virus and the lockdown, etc. situation will last. But the satisfaction which one has of a personal hearing and cross-examination in person, of course, it's difficult to replace it with virtual hearings.
Yeah, well, we'll see. We'll live and learn.
That's right.
Thank you very much, Sir Bernard and Justice Malhotra. We do have a lot of questions which are pouring in, but we do realize that we have to come to an end of this exciting first series of our interaction. On behalf of MCIA, we thank you for joining us. We thank all the attendees for joining us. Keep it tuned. We are having a next session coming up on Thursday at 4 p.m. India time, where we'll have 2 more distinguished guests joining us. We'll have Mr. John Beachy, who will be interviewing Mr. Harish Salve. Once again, thank you very much, Justice Malhotra and Sir Bernard, for joining us today. Thank you.
Thank you very much. Thank you, Justice Malhotra. It's been a great pleasure.
Thank you.
Bye-bye.